Thank you, Lara. Members, welcome to our final class of the Legislative University. Again, if you've been joining us for the last couple of days, we began our courses with a history of gaming in Florida, went over the Indian Regulatory Act, enforcement, and commissions throughout the U.S. And earlier today, we focused on live racing and games decoupling. So this course will be discuss the 2021 Gaming Compact with the Seminole Tribe. And we have representatives from the tribe and the governor's office, in addition to our own Kurt Hammond. While we will discuss the 2021 Gaming Compact, this is an opportunity to ask questions and to gain information. It's not a committee hearing, nor is it a venue to editorialize or frame questions to make a point. So our goal with these courses is to provide you with a basis of knowledge on the different aspects of gaming prior to special session next week. Having reps from the Seminole Tribe and the governor's office gives us an opportunity to ask those questions directly. If you have questions, hit the hand raise button on your WebEx screen. You'll be called upon in the order that you raise your hands. And with that, I want to thank our presenters and turn it over to them so we can get started. Presenters, thank you.
Great. Thank you very much. I'm going to be opening it up for those of you that I have not had a chance to meet and work with. My name is James Uthmeyer, and I serve as the governor's lead on the negotiations with the tribe related to the compact. I say it was a privilege, though in hindsight, I'm not sure it's something I would have signed up for. It was a long and tough process, but I do believe that we have put together a compact that is in the best interest of the state. Is it a perfect deal? No. Is somebody going to be able to point out something they would love to have better? No. But that's the case, I think, with any big and important deal. I think this deal is certainly in the best interest of the state government. I think it's in the best interest of the state workers and jobs. I think it's in the best interest of the tribe. At least I hope they still agree with that. And I think it's in the best interest of the state's pari-mutuel businesses. An industry that I know has looked at these negotiations cautiously and is worried about predictability in the future. As most of you now have probably come to know, we are governed by a very unique environment in Florida, and that is Amendment 3. There can be no new casino gaming expansion in the state by legislative act alone. It must be done through a constitutional referendum. So that puts together a pretty complex spider web of regulations that dictated the way this negotiation would have to take place. Would I have liked to negotiate in a different environment? Sure. There are a lot of different things that could happen, but that's the ballpark in which we are playing. So I guess if there's one loser in this industry or in this compact, it would be somebody that really wants Florida to turn into Las Vegas. Because of Amendment 3, that just cannot happen. You are not going to have big casinos in every corner of the state, and I know many of you probably appreciate that. So I'll start out with kind of the main points. I think by now everybody knows this is a long deal. It is a 30-year deal. This is a longer deal than the last one for a couple big reasons, and I will let the tribe, follow up after this and kind of describe some of their pros and cons. But it's a longer deal because we need to have a little bit more predictability and stability for the state. We weren't even halfway through the last deal before it started to fall apart. So this will help us kind of kick things down the road a little bit. And number two, the tribe is going to be investing significantly in three, big new construction projects, new casinos down in Broward County. It's going to take several years to complete that operation, and I don't think they're willing to invest the significant sums of money if the deal's going to end shortly thereafter and exclusivity could be in jeopardy. The key to the deal is a $2.5 billion minimum over 5 years. This was something that the tribe eventually agreed to put the state in a place of predictability going forward. We know we haven't been paid for over a year. The tribe certainly has some good arguments as to why they have not been playing, arguing that the operation of designated player games in the state have breached their exclusivity My deputy, Ray Treadwell, the former GC of DBPR, will chime in for a few minutes after me and can elaborate on that slightly. But the reality is that the tribe was not paying for games that are ongoing in the state. Again, they had good reasons to not be paying. I won't provide any conclusive statement on the law because I certainly think it is a complex issue. But we needed to get the state back in a position of receiving revenue share and repairing our relationship with the tribe. The tribe has been a good partner in the past, has provided billions of dollars to the state, and under Amendment 3 is the most legitimate party to be able to bring new gaming into the state. Going forward, we anticipate, roughly $6 billion over the next 9 years, and I'll point out that $2.5 billion here in the first 5, that is a floor. That's a minimum. If their operations on sports betting and new gaming, if that turns out to be more profitable early on than envisioned, the state will certainly benefit. A point I want to make right out of the gate is that there's no likely avenue through legislative act alone for expanded, commercial industry in the state. I know there are some differences in legal opinion, but I think the prevailing view is that just can't happen. You'd have to go through a constitutional referendum. So people that think that we could create a commercial world where dozens of commercial sports betting companies could come into the state, that's not likely to be possible. So we know what world we're in. We've got to deal with a tribal compact. That is the one carve-out exception under Amendment 3, and that's what the governor's office has set forth to do. So what does the tribe get in this compact? I'll list out a few things. 3 new facilities at the Broward Reservation. So if you like gaming, if you like going to Vegas, you should enjoy this. It's a great tourist destination that will undoubtedly bring visitors to the state who will spend money and I hope have a safe but good time. If you don't like gaming and you don't want to see a giant casino, at the end of your block, that you should appreciate this too, because it's limited to the existing footprint there at the Broward Reservation. I think most of you have probably seen the beautiful Guitar Hotel on your drive. The tribe will get craps and roulette as part of the compact at its facilities, and it will get some geographical protections. Here we're in a situation because the tribe's exclusivity was breached in a slight fashion, and I hope I'm not offending the tribe by saying, I don't think some of the small designated player operations are huge competitors for the tribe, but the reality is under the existing compact, it's arguably been a breach. So again, I think they had good reasons for not paying. Here, we don't want to be in the same situation again. So if there's a constitutional referendum that brings new gaming into the state in a certain location, or if it brings sports betting into the state, we didn't want the state to suddenly lose all revenues just because of that event happening outside really of the state's control. So the tribe made a concession, and they've got a 100-mile radius around their facilities, where if a constitutional referendum takes place that authorizes new gaming in an area outside of that 100-mile radius, the deal will not change. If somebody does lead to new gaming within that 100-mile radius, then the tribe will be allowed to withhold revenue shares from the facility where the breach has occurred. So I kind of consider this to be the eye for an eye model, and I think it does a lot to protect the state from a situation like we're in right now. The final thing I'll say here on what the tribe is getting out of this, and again, they'll be able to talk further and answer questions, is the exclusivity of a tribe-operated sports book. The operations would have to be through servers on tribal lands that either the tribe operates on its own or through a vendor that the tribe would enter into agreement with. But under federal law, under IGRA, the tribe, per this compact, would need to be the operator. So again, people that would love to be in an environment where we can have free-flowing competition, forgetting the policy implications of whether you want a lot of gaming or not, there's no realistic scenario where that can happen in Florida under Amendment 3. Through the operation of the sports book, we did include language that will allow the pari-mutuels to partner with the tribe at their choice to provide Marketing services. What does this mean? This means they will be able to offer their own statewide skin. That's a key term in the sports betting world. A skin is basically an interface, a website, an access point for people in Florida to make sports bets. But the underlying sports book would again be run by the tribe or one of its vendors on tribal lands. Parimutuels would get a significant cut on the parimutuel skins. 60% of the net win there would go to the parimutuels for their marketing services, and the parimutuels would be able to customize and change the design of their skins at their discretion. If they want to put their brand name, a logo, the layout, they would be able to have some personality at their choice. Again, they don't have to participate, but we think it's a really great aspect of this deal to bring two sides together in partnership that haven't necessarily always seen eye to eye or gotten along in the past. Again, I've talked about it a little bit. What does the state get? $6 billion over the next 9 years, economic growth to the state, jobs, infrastructure projects, tourist gaming destinations, and protections for the Florida parimutuel industry. I know in the past, in these deliberations and negotiations, the parimutuels have not always been important to those involved. To the governor, the parimutuel businesses, that he sees those as his constituents. We very much wanted to protect their continued existence, and that was a non-starter. That was a deal breaker. We were not willing to cave on the parimutuels. Let me be very clear. We fought for the parimutuels from the beginning. So the games played by parimutuels up until April of this year, the tribe has agreed that continuing operation of those games will not breach exclusivity. In addition, tables, while there are going to be limits in place to just ensure nothing gets out of hand and nobody takes advantage of this deal, those limits are going to be 10 designated player tables in counties with slots and 30 in other counties. We've run the numbers. We've had inspectors look at table operations. Currently, I don't think anybody is close to breaching those limits. So we think that those are fair limits to preserve the existing footprint of the designated player games and give parimutuels some reliability and consistency going forward. That you guys are here to stay if you want to be. If for some reason in the future the parimutuels should no longer be able to offer designated player games for one reason or another, then there is a percent increase to the tribe, 1% per stepping scale category, and I'll mention that in just a minute, that the tribe would have to pay. So the state would make more money as the tribe's exclusivity would grow. So let me talk a little bit more there about the revenues to the state. Let me make one key point out of the gate. Under federal law, a state cannot tax a tribe. That cannot happen. So when people are talking about comparing this deal to other states and the amount of money that Florida could receive to other states, please know that other states that don't have Amendment 3 might have the ability to tax certain games at rates that far exceed what we're going to be able to receive under a tribal compact. Rates of 30, 40, or more percent. I assure you there is no certain situation where the Department of Interior would approve a compact where a tribe is getting taxed at 50% or something like that. We are also bound by the percentage rates from the last compact. So though the state cannot tax a tribe, we can receive a revenue share payment from a tribe commensurate with the added exclusivity, the benefit that is given to the tribe. So we are providing new facilities, new casinos, a couple new games, sports betting, and we are then going to be able to increase the revenue share as a result. So the step-by-step range, and you should have made available for you on a website, or we can find another way to get it to you if it hasn't made it to you. Two different documents. One is a summary of the compact that we put together. Another is a Q&A that addresses some of the questions our office has been fielding. If you don't have those in front of you today, don't worry. That they should be there for you for your reference. And I know you have an extremely knowledgeable and talented staff, but if you need additional clarification on things, the Governor's Office of General Counsel is always here to provide answers. So the stepping scale, we actually have an increase in the percentage payments this time around than we did in the 2010 compact. Table games range from 15% revenue share all the way up to 25 on a sliding scale from 0 to 2 billion or more. I won't go into the nitty-gritty there, but that is an increase from the last compact. And if you have questions about the details, again, we're happy to help. On slots, raffles, and drawings, the percentage rate will again be 12 to 25, which was the same rate generally as 2010, but the sliding scale increases faster. So as the tribe makes more money and grows, which it's definitely going to do with 3 new casinos, the amount of money to the state will more quickly increase. Sports betting, the percentage rates, there are 2 different rates. Number one, if the revenues, if the net win is coming in through a tribe operated skin, not partnering with a parimutuel, the rate to the state will be 13.75%. 13.75% is the equivalent of the highest tribal percent that's already out there. And it's actually higher than most states that offer sports betting. The average is somewhere in the 8 to 12 range. There are certainly a few states that have higher percent shares, but those are commercial industry states not governed by Amendment 3, where they are able to tax. So 13.75, we believe, is a very generous rate to the state. Obviously, the more success the tribe has on sports betting, the more success that the state is going to have in its revenue share. And we do believe that Florida is a prime state for sports betting, given the large number of teams we have, the tourist destination we have here, and the number of visitors that might want to come here to participate in sports betting or go to a Bucks game and have some fun with some wagers on the side. When it comes to the sports betting operations that are run through parimutuel skins, the rate there will be 10%. And the reason there is twofold. One, we wanted to incentivize the tribe to work well and promote the parimutuels. If the parimutuels do well, then the tribe is going to have a lower revenue share rate to the state. The second thing is we wanted to allow more margin there on those revenues so that the parimutuels can find success as well. If you look at the 60-40 split on the revenues coming in through the parimutuels, the tribe would be getting 40%, not 60, and then the 10% net win would come right off the top. So in effect, the tribe really has a revenue, rate, not a tax rate, but a revenue share rate of about 70% on sports betting through the parimutuel marketed skins. The final couple points I'll make are one, there is no online gaming that's contemplated in this deal, other than a goodwill provision for the governor to continue negotiations in good faith with the tribe. We've made very clear there's language in this compact that says the dispute resolution mechanisms that the parties have to be able to bring a court action or go before the gaming commission that I hope you all are going to create soon. That doesn't apply to that phrase on the online sports betting. In addition, I think there's been some misinformation that under federal law, under IGRA, if the state were not to negotiate in good faith going forward on online gaming, that somehow the federal government could come in and give these games to the tribe. That is not true. Under federal law, under IGRA, the state does have a duty to negotiate in good faith, and the tribe can complain if that doesn't happen. If the game is already legal in the state someplace for some reason. Here, the legislature would then, in a future date, have to approve a new compact that does allow online gaming, and you'd have to ratify that. So you remain in control there. There's no way that somebody can go flip a switch and change the situation. There's no enforcement mechanism for this phrase. It was, a goodwill note that, look, you're going to be a good partner to the state. We're going to be making $500 million or more over a year. We'll pick up the phone in a couple of years if you call, but we're going to do that anyway. We're going to do that for our partner. The governor right now was not even willing to talk about online gaming, does not feel comfortable with it, is not willing to contemplate it. That was a deal breaker right from the beginning. That's our view. And if that's your view too, then I think we're in agreement. If some governor down the road should change tune, change perspective, any change in the online gaming situation would have to be reviewed and ratified by the legislature and then approved by the Department of Interior. So, sports betting, I know there are questions about the legality of this hub and spoke model. If that's a new term for you, then the hub and spoke refers to the servers, the engine, the operations being on tribal land, with the spokes being cell phones, interfaces that people can access statewide. There's no case directly on point here. We believe that this deal is constitutional. I'm happy to have a more in-depth conversation on legal, but I know you have, your own general counsels, you have a legal team that can provide some input. I will say only this, that there is historical precedent that a bet is made where received, and if it's received and processed on the servers on tribal lands, then it is gaming on tribal lands that falls under a compact as an exception to the requirements or restrictions, I should say, of Amendment 3. Again, happy to talk more in depth with people on that. I don't want to get into, legal nerd zone here and put everybody to sleep, but we would not, the governor would not have signed this deal if we did not believe there were strong arguments defending the constitutionality of the compact and the sports betting component. That said, no lawyer goes into a negotiation and a compact without planning for contingencies and risk. If a court should disagree with us and should invalidate the sports betting component as violating Florida's constitution or some other legal restriction, then that aspect of the compact would essentially fall off. The tribe would no longer be able to do statewide gaming. The tribe could still do sports betting on tribal land, but the sports betting component would not be able to take place on statewide servers, and thus, therefore, people would not be able to play. The revenue share for sports betting would go away, but all the other revenue shares to the state for games physically on tribal lands would continue to take place. So we would not be in a similar situation we're in today where we lose $400+ million because of a slight breach. We would continue to receive actually more money for those games than we otherwise would be receiving today had we not had the alleged breach of exclusivity. In addition, there are rumors that maybe somebody in a future time would bring a constitutional referendum to bring sports betting into the state. If that would happen again, that's no fault of us as state government officials. We can't control what the outside parties do, and thus we shouldn't be punished for it. So if the tribe loses exclusivity because of that, then the tribe will no longer have to make revenue shares on sports betting. But again, the rest of the deal would stay the same. Now, if the legislature decides at a future date that it wants to create new legislation, if there's a legal way that somebody devises to do that, to bring commercial sports betting into the market, then that would be a breach of the tribe's exclusivity that would lead to non-payment for all aspects of the deal. And there, I think the view is that is something we can control. That would be a direct breach of the tribe's exclusivity, not something that happens outside of our control. I think there are probably a host of lawyers out there that would say there's not a constitutional way to do that at this point, but I will let them speak, not me. So those are the primary points I want to make. Again, I will have Ray, my deputy, speak in just a minute. He can offer, a little bit more commentary on the unique landscape that we inherited, and then I'll let the tribe speak after that. It's great to have Joe Webster, my counter, on this call. We had some difficult conversations. I think he was pretty frustrated at me at times, and there were certainly times where we didn't see eye to eye on things. But I can truly say both sides made serious concessions, which needs to happen more in the world, in my opinion. And we've come up with a deal that I think benefits everybody as best you can in this environment in which we lead. So if you love gaming, you're going to like having a couple more opportunities for destination. If you don't like gaming, it's here in a limited fashion. And as you probably know, it's already been going on in many locations, and our research has showed that sports betting is occurring right now underground, not legally within the state, but it is happening in large numbers. This gives us a way to bring something that is seemingly very popular in the state, that is polling very high. It gives us a way to bring it into the state in a way that the state controls, that is legitimate, above board, that we can shine a flashlight on, and that we can benefit from significantly as we return to a revenue share agreement with the tribe. So thank you very much. Thank you to Joe and Jim, if he was able to get on the phone with us, for working hard and putting up with me through the late nights over the last couple months. And I'll turn it over to Ray Treadwell, my deputy, to pick up where I might have left off, and then we'll move on from there. Thank you. Ray, I think you're up if you're there.
All right, I think I'm off mute now. Good afternoon, everyone. As Mr. Rothmeyer mentioned, I'm his chief deputy here in the governor's office. Prior to joining the governor's office, I was general counsel over at DBPR in 2019 and 2020. So I have deeply studied the relevant legal issues here. And as I went through on Tuesday, the main point I'd like to get across is that we should all remember the dilemma that brought us to the recent impasse with the tribe before the tribe stopped paying. And of course, as Mr. Rothmeyer mentioned, that issue was whether designated player games are banked or not, in violation or not of the tribe's exclusivity. Well, in 2016, a federal judge, Robert Henkel, agreed with the tribe that the designated player games are banked card games and violate some form of the tribe's exclusivity. So you got this case over here. And then in 2017, after DBPR tried to eliminate the designated player games by repealing the rule governing the games, the First District Court of Appeals here in Florida, the state appellate court, stopped the repeal and protected the games as a permissible form of poker, at least in concept. So the state lost 2 consecutive lawsuits during the previous administration, putting the compact revenue in ultimate jeopardy unless the legislature devised a way out of those walls closing in, the legal walls. And as you know, since 2017, there has been no easy solution out of this impasse that all interested parties in Florida could reasonably accept and that could get around Amendment 3. So what this new compact represents is a hard-fought compromise and a creative path forward in what has previously been a very lucrative relationship with the well-renowned partners in the Seminole Tribe and Hard Rock. So again, very briefly, the choice with this new compact, I believe, is simple. Either renew and expand our mutually beneficial relationship with the tribe and Hard Rock, or the state remains stuck in between a hard place and a rock. Thank you very much. I believe it's going to be Joe Webster now speaking.
Actually, I think that Jim Allen was able to join. So I don't know if he's, Jim, are you on?
Was he calling in on a phone?
I believe so.
Okay. Give me one moment.
This is Jim Allen.
You're on.
Can everyone hear me?
Yes.
Yes, sir.
Great. Well, good afternoon, everyone, and we sincerely thank you for the opportunity to make this presentation this afternoon. On behalf of Chairman Marcellus Osceola, the Tribal Council, and Mr. Jim Shore, the Tribe's General Counsel, we certainly appreciate the opportunity to take a step forward in this partnership between the tribe and the state. I certainly am very impressed with the presentations that have been given prior to my remarks, and do not have any dispute as to what has been stated. I probably would add just a few comments, and then maybe just a few more of the business philosophy behind the tribe and Hard Rock, as we obviously try to take this next step into potential ratification by both the House and the Senate. First of all, I appreciate the state, acknowledging, some of the challenges that occurred with the designated player games. But I do think it's very, very important for everyone to truly understand the big picture. The 2010 compact was signed, and even prior to that, these type of games started to appear in other states and jurisdictions. There are meeting minutes and records that go back to quarterly meetings between the Seminole Tribe and the state of Florida. I attended virtually every one of these with Joe Webster and Mr. Jim Shore, the tribe's general counsel. And in every single meeting for years, starting in 2011, when we actually sent a letter to the governor stating we are concerned that these games are a true Class 3 banked game. We had put people in the facilities that were actually placing bets with outside banks, and we truly said we wanted to work through the issue. At that time, certainly, conversations started about discontinuing revenue share, and the tribe always said no, and we continued to pay. Obviously, as James indicated, we continued from early 2011, all the way through mid-2000, I believe it was April of 2018. And the reason for that is because we truly do value the partnership between the tribe and the state. The tribe clearly understands that a long-term relationship with the state, in the mindset that Florida is a family-friendly place and that we do not want to become Las Vegas of the East. And that certainly has been told to us by this administration and all the prior administrations that I have worked with in the state of Florida during my over 20-year career with the tribe. I do think it's important to note that when we look at Florida, the Seminole Tribe is guaranteeing a minimum of $500 million a year in the first 5 years. And as James stated, with a projection over the next 9 years of $6.4 billion to the state. If we look at pre-COVID, the last publicly reported numbers of the Las Vegas Strip, there is 140,000 slot machines. The tribe has 12,178. There is 5,445 table games. The tribe has 524. All of the combined casinos on the Las Vegas Strip paid the state of Nevada $444 million. The Seminole Tribe is guaranteeing a minimum of $500 million a year. It is the most historic guarantee by any tribe or company to any state jurisdiction, whether it's Native American, from any business, whether it be the publicly traded commercial companies outside the state of Florida, or obviously any tribe within the United States. So why did we do that? Because frankly, the certainty of the term of the next 30 years was something that's very important to the leaders of the tribe, but most importantly, the children of the tribe. The tribe is always about families and growing, the education, the history, the culture of the tribe. And so we always like to remind everyone when we look at the state of Florida seal or we look at the state of Florida flag, that is a lady that is of Seminole Native American heritage. That lady doesn't come from New York or Las Vegas or any other foreign country. The Seminoles have obviously been in Florida forever, and they truly value appreciate the relationship with the state itself. I also think it's important that when we talk about these guarantees, the tribe has made revenue projections and guarantees in the past. And not only did we meet every single one, but we also exceeded them. Unfortunately, some of the people that are opposed to this agreement have made many promises to the state. One company said tribe should pay $1 billion. And I said to one of the senior officials of the state of Florida, I said, ask them if they want to guarantee $1 billion. And obviously the answer was no. So I think that when we look at our previous presentations to the state, and certainly this can be validated with Amy Baker's office, we 100% do not create projections in order just to obtain votes. Our information is sincere, it is trustworthy, and it is honest. We enjoy investment-grade ratings from Moody's, Standard & Poor, and Fitch. In the history of our industry, whether it be all the major gaming companies, whether it be companies like DraftKings that frankly have lost $1.8 billion since they've started, No other company has enjoyed simultaneous investment grade ratings like the Seminole Tribe and Hard Rock. So we feel that the partnership is with two super powerhouses, the state of Florida and the Seminole Tribe. And if the state wants to continue to protect Florida's family image, then the tribe is the solution. Because we all know, those of us that have been monitoring this issue literally for decades, the goal of the people that are opposed to this is to create gaming all over the state of Florida. The only interest the tribe has in expanding gaming with the state of Florida is with the pari-mutuels. And it should be noted that I have testified in the Capitol and in many committee hearings many times through the years on behalf of the pari-mutuels, including lowering their tax rate, including serving of alcohol, including locations of ATM, security, and many, many other issues that help support the pari-mutuels. But this time, this is a new partnership. And there are those who say, well, how is it going to work? Well, what we have been doing now for weeks is meeting with the pari-mutuels. And I can sincerely tell you that once they understand how this hub and spoke model can work, it is truly a new business for them. And for full transparency, as James mentioned, yes, we had some spirited debates on what the economics should be. The tribe's original position was the tribe should get the majority of the profits on the online sports betting. But the state stood firm. Even though the tribe is investing hundreds of millions of dollars in its technology platforms in order to potentially have this opportunity, not just in Florida, but on a global basis. So from our viewpoint, it is extremely important to cultivate those relationships because that's the model that expands the gross gaming opportunity, which obviously creates the additional revenue to offset the $500 million payments that the tribe is agreeing to. There are 4 recognized national studies on this topic. And all 4 of them have projections of nothing less than $180 million in actual profit after expenses and taxes on the low side. And on the high side, I believe there's one study at $280 million. And that is after a 3 to 5 year ramp up. So hopefully this demonstrates the tribe's sincerity about wanting to grow the business because, frankly, the pari-mutuels, our potential new partners in this category, can really be the catalyst to that. James mentioned something I think that is so important. The reality is the tribe, under federal law, did not need to pay the state of Florida any money until the year 2030 if a new compact was renegotiated. The tribe stated its position numerous times that if the state closed down all of the designated player games, yes, it was prepared to resume its revenue share immediately. But as James indicated, obviously there was some conflicting legal decisions there, so we were at a standstill. So think of this. The tribe is taking the risk that even if it loses a potential legal challenge, it is still guaranteeing, with no exception, paying its revenue share on its land-based operations. So voting no for this potential, compact is voting against a $6 billion payment to the state of Florida that it wouldn't have received, obviously, if this document was not negotiated. In closing, one of the things that I actually personally showed the speaker, the American Gaming Association, which is the largest association in the world that is recognized by everyone in our industry, states the following. There is over $7 billion wagered from the state of Florida alone on an annual basis in offshore illegal gaming activities. So finally, the state of Florida will be able to regulate these particular businesses. And obviously, with a partnership between the state, the tribe, and the pari-mutuels, we will be able to create additional jobs. The estimate on jobs just related to the sports betting is 2,200. and obviously a tremendous amount of revenue for the state in revenue share from the tribe. The total projection of revenue share of this deal between the Seminole Tribe of Florida and the state of Florida is in excess of $25 billion over its term. Frankly, we have models that show it going over $30 billion. So it is truly a legendary, historic opportunity for the tribe to be potentially given this opportunity, but certainly its amazing success that it's had through its culture, obviously through its business activities, is also a sure bet for the state of Florida. There are so many companies that are trying to derail this, but when we look at them and we actually look at their profitability, we know a better relation comes forward between the state and the tribe. One final comment. Yes, there is a highlight of about 3 potential resorts in South Florida. It's very important, even if you read going back to the 8 or 9 compact, the tribe has always had the ability to expand with new building or buildings or replacement of its existing facility. We just wanted to highlight and clarify that if we see our existing expansion, which we just spent in the state of Florida, $2.2 billion in actual hard dollars, with a ripple effect of over $6 billion, adding over 4,000 permanent jobs, created 2,200 construction jobs. Those opportunities could come in the future, then the tribe obviously is more than prepared to do so if business warrants that. With that, I will yield to Joseph Webster, who is the tribe's outside legal counsel from Hobbs Strauss, that will explain the legalities of this compact. Thank you.
Great. Well, thank you and good afternoon, everyone. I guess to start, I would like to say, as James indicated in the beginning, I mean, it certainly was a hard negotiation, but very much appreciate the professionalism of the state's negotiating team throughout, to reach this, this agreement, which really is historic. As Jim Allen said, there's no compact between another tribe and a state in the country that comes anywhere close to this in terms of a guarantee. And the parameters of the compact are strictly regulated by federal law, by the Indian Gaming Regulatory Act, that sets specific limits on what topics can be in the compact. As James indicated, the statute is very explicit that the state cannot impose any tax, fee, charge, or other assessment on the tribe with respect to the gaming. The only opportunity for the state to receive a revenue share is in exchange for something of value such as exclusivity. And even if the tribe and the state agree to those terms, they're still subject to review by the U.S. Department of the Interior, that has its own responsibility to review the numbers, review the projections, and make sure that it agrees that all the provisions of the compact are lawful and that the payments are in fact commensurate with the value of the exclusivity received. It's not uncommon, in fact, for the Interior Department to disapprove compacts, even when the state and the tribe are both in favor of it being approved, because their review is independent of the views of either the tribe or the state. As James also, I think, explained very well, and as Ray also helped to give the history, what's really critical here is having reached a previous agreement on the value of the exclusivity. Once that was violated, in order for there to be a resumption, there has to be some new value. And in this case, particularly since the tribe is agreeing to a significant exception to its exclusivity for the designated player games, there has to be additional value. And so that additional value, much of that is, the sports betting, the additional games, but this is something that, again, it's not just up to the parties, it is subject to a strict review. I will say too, in terms of the structure, there have been some questions about, the hub and spoke model. It's important to note that one of the areas that IGRA does allow a tribe and a state to negotiate is allocation of jurisdiction. And so the approach that's been set up here in terms of the bets being deemed to occur exclusively where received is just that kind of allocation of jurisdiction. It's an approach that's been used in, I think, at least 8 states so far in terms of not involving Indian tribes, but the legal construct, which is the same in terms of deeming the transaction to occur where received, as well as there is some federal precedent on this as well. So, again, I think we're, agree with the state, that the approach is absolutely defensible. It's one that's consistent with IGRA. It's consistent with Amendment 3, which has a very specific carve out for gaming, with a tribe pursuant to a compact. And so, with that, we think that the overall framework is one that Interior will approve and will certainly be defensible should there be a challenge. And so, with that, I guess turn it back to James, or see if there's any questions. So, thank you.
Thanks, Joe. Thanks, everybody. Again, we appreciate it. I'll say one final thing, and that's, I know how long, draining, and tiring a session can be. So thanks to everybody for having the encore here and coming back to learn about an area of business and gaming that is very complicated and shouldn't be taken lightly. But it's important for the state, and we appreciate you giving it a hard look. Thank you. Thank you. Kurt?
Thank you. I think Lara is going to start letting in questions.
Yes, Representative Roth has a question.
Good afternoon. And before I start, I wanted to thank Kurt. He's been giving me top billing. I've been in the top left-hand corner of the screen for 2 days now. Thank you, Kurt. Little joke there. James had a comment going about the 100-mile radius. Obviously, Palm Beach Kennel Club is within 100 miles of Hard Rock Cafe. So could you go through that again about the exclusivity? You mentioned the 100-mile radius.
Sure. Yeah, I think there's 2 different types of radius we need to talk about. The first is a constitutional referendum. So if some company says, we want to come in and we want to drop a big casino in Sarasota that's going to be within 100 miles of Hard Rock Tampa, and thus that would be a breach under the compact, and the tribe would no longer have to make revenue share payments from that Tampa facility. If somebody drops something, and 30-minute drive out of Immokalee, again, that's going to be a breach to the tribe's facility there. So this is constitutional referendum where the voters ratify an expansion of gaming activity somewhere in the state. The second geographical restriction in the compact talks about the portability or movement of slot licenses. So here we don't believe the compact should really get in the middle of what Florida law does or does not require. That's for you guys to decide. But what we wanted to do is be as permissible as possible under Florida law, and also protect, the tribe's exclusivity in certain geographical areas. So the compact, does not restrict a slot license from moving, so long as it's, within 15 miles in South Florida of any Broward tribe facility, or within 100 miles of Hard Rock Tampa, of the other facilities. So there, again, you guys, under Florida law, I'm not saying some of those license moves can take place. I think there are a lot of restrictions, and obviously you've got the constitutional considerations as well. But we wanted the compact to speak to that as little as possible, so that it would be a matter more appropriately decided by you, the legislature.
So could I follow up, please?
Yes, please.
Yeah, so I thought I wrote down that this was dealing with designated player games. Does that mean, is there a restriction of having additional, you cannot have any additional designated player games within 100 miles of the Hard Rock Cafe, or what? Or maybe I misunderstood what you said. related to a 100-mile radius as it pertains to designated player games?
Sure. The compact does not restrict movement of pari-mutuel facilities. Slots accepted. That's a separate situation. Obviously, Florida law has some restrictions, and there are local kind of referendum requirements. But the compact does not restrict movement under state law unless there's a designated exclusivity concern that's laid out. And I invite Joe Webster if I'm missing a point to jump in as well.
Yes, sir. Okay.
So I was going to say, I think that's right. I mean, the limitation is, if the facility is in a county where there are slots, then there would be a limit on the number of designated player tables they could have, which would be 10. But if it's in any other county, then the limit would be 30.
Okay, yes, right. So you clarified that because you said it twice, and I just wanted to be sure. Can I have one more question, please? I think you mentioned when you're doing designated player games through the tribe that the state would get 13.75%. And so I was asking what would be the take that the state would get if it was a designated player game, obviously at a pari-mutuel?
So I think here what I was referring to is the sports betting component. So if you are accessing a skin, a website or an app that's run by the tribe, it's 13.75. If you go through a pari-mutuel's skin, then it would be a 10% revenue share to the state. And then when it comes to net win, the split between the pari-mutuel and the tribe would be 60-40 for the pari-mutuel's marketing service in favor of the pari-mutuel.
Okay, thank you.
And I'll just add as well that currently under Florida law, pari-mutuels, the poker games of pari-mutuels are being taxed at 10%. So that's the status quo right now, and that, as far as I know, won't be changing.
Okay, thank you.
All right, we have got a question from Representative Thompson.
Thank you very much. Good afternoon. We have cruises to nowhere in Central Florida. Our attractions jealously guard the family-friendly image that they've built over years. But we do have the cruises, and I'd like to know how those are regulated and whether or not they present any problem with regard to the exclusivity that the tribe is requesting.
Thank you for the question, Representative. I think you're talking about the cruise line industry.
Not necessarily. We have river boats, and we do have cruises that are operated by various entities, and they go out beyond the boundaries where slots and other kind of games are permitted. And I'm asking if that presents a problem in terms of exclusivity and how those cruises are regulated.
Okay. Joe, you might be more appropriately positioned to answer this one. I don't want to say something you disagree with.
Sure. Yeah, so the representative, as I understand the question, the cruises to nowhere, as you said, the gaming doesn't actually take place in the state. Instead, they go out into international waters, and the gaming is conducted there. I believe it's regulated by federal law. There's kind of a specific statute that deals with slot machines on cruise ships. Yeah, it's an issue that in the past I know has come up, but it's not set out as an exception. I mean, it's not set out as a violation of the tribe's exclusivity.
That's what I wanted. Thank you very much.
Sure.
All right, Representative Woodson has a question.
Thank you very much again, Kurt. We cannot thank you enough. I'm telling you, you really lighten us on this subject, and I really appreciate it. My question, I have two actually. The first one has to do with the 3 casinos that I mentioned that will be built. I have to say as well, I live 5 minutes from the Hard Rock. So this is affect my community, impact my community, and I want to have some clarification on some of those things. For the 3 casinos that will be built, which led us to believe that revenues will quickly increase, how was the estimation of additional revenues calculated? What factors were taken into consideration when doing this calculation? Anybody who wants to answer it.
Yeah, I'm happy to provide an answer, but I'll defer to the tribal representatives first, since it's, you know, their facilities that are envisioned. If you guys want to answer.
Jeff, do you want to respond on that? I don't know if Jim.
Jim is going to answer that question.
Okay.
Okay.
If not, for the sake of time, if you want to provide me with the information, I'll be more than happy to get it at a later time if you don't have it right now, for the sake of time and respecting everybody else's time.
I sent the request
Okay.
to have him unmute, but it has not been accepted yet.
It's a little trickier to do it on a call.
This is Jim Allen.
Oh, there you go.
Representative, my apology. I kept trying to unmute myself, but technology was slowing me down.
Okay.
So first of all, there is no plan at this time for any expansion of the tribe's gaming facilities in South Florida. As we mentioned, we just finished up a $2.2 billion expansion prior to COVID. So certainly it's going to take a few years to make sure that the business could warrant a potential expansion. So that language is really about addressing the term of the compact, which is, 30 years, that the tribe does have the ability and acknowledges that that is something that could happen in the future, but no plans at this time.
Okay. So there's no plan, but it's in there just in case it might happen, it might not happen. So it would be good actually to have an estimation should it happen. That's what I'm saying. Should it happen? Because it's in there. You can come in at any time, right?
Yeah, well, even if the tribe, a year or two from now decided that it wanted to take this potential step, it would take a minimum of 6 to 8 months to design it. And then, as you probably saw with the guitar, it took over 2 years to build it. So there certainly isn't anything occurring in the near future. But, frankly, and frankly, we're very encouraged about the people we employ. We, if the business continues to grow, then yes, that is an option that the tribe certainly has the right to do so, not just in this compact, but in the previous compact.
Yeah, I appreciate that. We're looking from both sides. We're looking for the state, not to violate whatever is in the compact, but we're also looking at the tribe. Should something like that happen, where do we fall? What should we expect to get as well? So this is why I'm asking. Thank you so much. The second question has to do with the U.S. Department of Interior that will review the compact, the review process by the Department of Interior. Can you walk us through what this process entails? How is it handled? Do they contact the state and the tribe to provide additional information? Because remember, this is a local issue and state issue. So do they look at also any community input? At any step of this process, was any community input taken into consideration or not? But I'm really looking for the Department of Interior. What information do they get from you, additional information, in order for them to be fair in the review process?
Joe, you've done this before. I'll let you go first.
Okay, well, sure. Well, Representative, the process that Interior follows is they're reviewing the compact, which is presented as an agreement between sovereigns, between the tribe and the state, to see whether it complies with federal law. And so once it's submitted, they almost always have questions, but the questions go to compliance with the various requirements of IGRA, including whether the revenue share payments are reasonable. They will often ask the tribe and or the state for additional information, particularly on revenue share, but there may be other questions as well where they'll ask for a written submission. And under the statute, the Interior Department has 45 days to act on the compact after it's submitted. They can either approve it or disapprove it. And if they take no action on it, then the compact is what's called deemed approved, to the extent that it's consistent with the statute. And then after that, then it goes to the Federal Register for publication. So it's only upon publication in the Federal Register that the new compact would go into effect. So the whole process takes about 50 days or so.
Thank you. And you know about the first one. Was there any problem when you had to get the first one approved, or everything went very smooth?
Well, I will say that the $1 billion guarantee was something that they had never seen before. As you may recall, the 2010 compact had a $1 billion guarantee over the first 5 years, and it was something that they definitely needed more information on. When Interior looks at a compact, they're not just looking at it, in isolation. They're also looking at it in terms of precedent for other compacts going forward. So it was necessary for the tribe in particular to really be able to explain the financial aspects of the compact, why that amount was appropriate, and how kind of all the numbers work together. So ultimately, Interior agreed, and they affirmatively approved the 2010 compact.
Thank you very much, sir. I appreciate it. Thanks.
All right, we've got a question from Representative Tant.
Thank you. I have a question. I've been seeing, I don't know if this is the right form, so you tell me if it's not. I've seen a lot of social media and other stuff kicking up about from the no casino side saying that this is an expansion of gaming. Can you address that? Why they think this is an expansion of gaming? Isn't an expansion? Like, can somebody address that?
Sure, I'm happy to take that one, Representative. Again, I don't want to speak for all lawyers out there because there is some debate here, but the prevailing view is that under Amendment 3, there can be no expansion of casino gaming without a referendum by the voters on the Constitution. I think the prevailing view, though certainly not the only view, is that sports betting, if passed by the legislature on its own, would be an expansion of of casino gaming in violation of the amendment. Amendment 3 does have an exception, and it does not prohibit new gaming that comes through a compact with a tribe negotiated by the state. So sports betting through a compact, we believe, is very legally defensible. I know some question the hub and spoke model where you have servers on tribal land that provide access to devices off tribal land. But as I already stated, and Joe followed up, we believe there is historical precedent that in a compact, we can dictate jurisdiction and we can deem the bet to be taking place on tribal land where it is received and processed. The servers, the operation, that will take place on tribal land. We would not have agreed to this deal if we did not believe it was constitutionally defensible. That said, we did build in a contingency where if a court should invalidate that plan and declare the hub and spoke model to be invalid, then that would sever from the compact and the state would continue to receive revenue share from all the other games. The tribe in that case would be allowed to continue sports betting live physically on tribal land, but the statewide network would no longer be able to take place. Again, we don't think that's the the likely scenario, but if it happens and the state can't control that aspect, then we've protected ourselves to continue revenue shares on everything else, which will be more than we were otherwise receiving in the past. I hope that helps.
All right, do you have a follow-up, Representative Tan?
Yes, that's fine. Thank you. I muted myself.
Okay. All right. Next, we have a question from Representative Davis.
Thank you. Good afternoon, everyone. So I'm not really sure who this question goes to, and it's just for an understanding. We are now going back to special session to decide on this compact, yes or no, right? So we are also dealing with a sovereign nation as far as the Seminole Tribe. When this compact is decided, and if it is decided a yes and it passes, who is really in charge? Is the state allowed to oversee the Seminole Tribe? Is the Seminole Tribe overseeing what it's doing with the state? We are dealing with a sovereign nation that really doesn't have an authority. So I guess my question is, once this compact is decided, who is actually the overseer of any of this?
Joe, I'll let you take it first from the tribal standpoint, and then Ray, if you want to follow up, please go ahead.
Sure. Well, Representative, it's a great question, and it's one that goes to the unique nature of Indian gaming. That in the context of gaming by a tribe, there's actually numerous regulators involved. So the Tribal Gaming Commission, which is an entity that is set up by the tribe, but the structure of which is approved by the Federal National Indian Gaming Commission, is the primary regulator. Under the compact, the state compliance agency, which has been DBPR over the years, but the state certainly has the flexibility to change that to a different entity, has an oversight role. And that oversight role includes being able to come into facilities, conduct inspections, review documents. There's audit provisions. There's frankly been a very good regulator to regulator relationship between the tribe's regulators and the state's regulators. And if the state believes that the tribe is not fulfilling its responsibilities under the compact, then there's a dispute resolution process that comes into play where ultimately the state could even go into court to force the tribe to take some particular action. But that's never been necessary because, again, the tribe has frankly a gaming commission that has been recognized as being exceptional. Just a quick aside, it was a few years ago, the tribe's gaming commission received what's called a certificate of self-regulation from the National Indian Gaming Commission. It's a very arduous process to achieve that status. Only a handful of tribes in the country have ever achieved it, but it recognizing the reputation, ability, capabilities of the Tribes Commission and how well it's done. And so that is a recognition and legal status that it remains in place to this day. I'll also note that in addition to the role of the tribal regulators and the state regulators, there's also oversight of different aspects of the gaming by both the Interior Department through the Office of Indian Gaming, as well as the National Indian Gaming Commission, which has an ongoing role with respect, again, to different aspects of the gaming. So again, hopefully that answers your question.
And I'll just add, I will echo Mr. Webster's comment about the cooperation between the state's regulatory body and the tribe's regulatory body. There have been no issues of uncooperation over the last decade, and so everything's gone smoothly there. And this compact really is going to govern kind of the activities that take place. And so the state is allowed to go onto these tribal facilities and make sure that the tribe is conducting the games in accordance with how the tribe has promised to conduct these games. So, I mean, the compact is going to be enforceable between our two sovereign entities. much like a contract governs a relationship between two private companies or two private individuals. And if one side's kind of going outside the boundaries of the terms of this contract, this compact, then we have a dispute resolution process. But in terms of the regulation, everything has been very smooth over the last decade, and we anticipate that going forward.
May I ask a second question? Laura?
Yes, go ahead.
Okay, really quickly. You all have mentioned a number of times about the hub and spoke model and the betting on tribal lands. Just a quick ask of, is there another model that could have been used, or this is the model that suits Florida and its regulation at this current time?
So under Amendment 3, our prevailing view is that the only way to do online sports betting statewide would be a situation where the servers are on tribal land. So this is the only way that we see this being possible. I know, again, some have theorized, you can read some blogs out there that there's a legal avenue to do it that does not define sports betting as casino gaming under Amendment 3. I won't comment on to whether or not that's the right view, but our view under Amendment 3 is that this is the only way to do it. You could do, just sports betting in person, but if you want to do it through all the apps that are becoming more and more popular, then yes, this is the other way, or through a tribal compact.
Thank you. This is a very complex topic, but you all have aided in us understanding it. Thank you, everyone.
Happy to help.
All right, next we're going to go to Representative Beltran.
Hey, good afternoon. Thank you. Just got two questions. The first is, I think I heard one of the speakers say this. I just want to make sure I heard you correctly and everyone agrees. This is what I've been told, in conversations I've had, is that we have a 2010 compact. We lost the revenues from that because we didn't enforce the exclusivity because we allowed the player-banked card games. If the state or DBPR were to ban those player-banked card games, the 2010, we would be in compliance with the 2010 compact, and we'd be entitled to revenues from that. Is that correct, or does anyone disagree with me on that?
Ray, you want to handle that one? You were the closest to it.
Sure. Overall, that is correct. I mean, if the designated player games are eliminated, then under the 2010 compact, I believe the tribe would resume making their payments. The problem we have right now is that there is existing case law from a state appellate court putting these designated player games in the same category of poker games that are currently authorized under Chapter 846. So the dilemma, the impasse is that, okay, well, these games may be legal under state law, but then violate what the 2010 compact envisioned as banked card games. And so it's that narrow space that we're existing in that makes it so problematic for just simply wiping out the games under the law as it currently exists.
Okay, yeah, appreciate that explanation. That is another piece that I'd appreciate that explanation. I didn't know that till today. Second question is on page 33 of the compact. This is waiver sovereign immunity, presumably for torts. If folks get injured at the casino and so forth, and it essentially seems to put the tribe in the same position as the state. But it says here, in no event shall the tribe be deemed to have waived its tribal immunity from suit beyond the limit set forth in Chapter 768. The next sentence says, as such provision may be amended from time to time by the Florida Legislature. So I just want to confirm, if we bump the limit in Chapter 768 for sovereign immunity for the state of Florida, those would then apply to the tribe in the future. If we modify 768, the tribe is going to take those amendments as we apply them to ourselves, the state. Is that correct, or does someone have a different read on that that provision of the compact?
Joe, you want to take that one?
Sure. Representative, you're correct. The language that's in the compact, basically the tribe has agreed to be subject to the same limits that the state has for itself. And so if those limits change, then, since that provision is cross-referenced and it's as amended, then the amended amounts would apply to the tribe as well.
Thank you all very much. Appreciate your answers and your presentation this afternoon.
All right, does anyone else have a question? Wave to the camera. Does that represent Hart? All right, give me one moment.
Okay, I'm sorry, I don't know what blocked me. Anyway, my question yesterday, and I was told I could probably find out today, was how different is our 2010 compact from our 2020? Are there some things that really jump out at us, or is it pretty close to the same?
Sure, I'm happy to handle that one. So first, there are modest increases in the revenue share payments. So for the existing games that are already going on, if you take everything else away, the tribe or the state would be getting more money as part of those revenue share payments. In addition, the tribe is getting new games, craps and roulette at its facilities. I think there's some debate about how popular some of those games still are today, but they will get to play craps and roulette. I've never played either, so I don't know if it's fun or not, but I'll leave that to others. The tribe will very definitively get the opportunity, as Jim said, to build 3 new resort-style casinos down in the Broward footprint if the tribe chooses. It doesn't sound like those are in the immediate plans. And as Jim mentioned, the 2010 compact did envision some, refurb and renovation already, but that clearly solidifies they'll get to build 3 more. And then, the big piece that everybody's talking about is the sports betting component. So that has not been an aspect of legal Florida gaming. We know that quite a bit happens underground or on the black market. And that's one of the reasons why the governor felt so strongly that we could go ahead and bring it in under our control and find a way to do it in a legitimate fashion that the state benefits from. So those are the big changes. I would say there are several new protections to the state that are in this one that are not before. Earlier, I referred to it as kind of the eye for an eye model. If something comes in that breaches the tribe's exclusivity in a certain region, then the state doesn't lose all the money from the tribe, just that from the region, the 100-mile radius. And then if sports betting should have a legal challenge to invalidate it, the state would still be able to recoup the revenues from the other games, the non-sports betting games. Those are the big changes. But otherwise, we view this as a continued kind of limited footprint of gaming where it previously existed, but restoring the state's relationship with the tribe and restoring our ability to collect hundreds of millions of dollars per year. I think she might have one more.
Did you say that we were still getting paid? So from the 2010, you're saying that the income never stopped, even though we did break the agreement, they were still paying, or no? I see somebody else shaking their head. So I want to really understand that, because my understanding was that it was broken. We were not getting any money.
So there was somewhat of a legal stalemate. You are correct.
Right.
A little, over a year now, year and a half ago, the tribe ceased payments. And Jim is right. The tribe spoke up for many months, over a year, saying, we believe our exclusivity has been breached. The state did not take an action to address that. And then the payments ceased in early 2019. So we are hoping to restore those payments and then some. Sorry, you're on mute again.
I get it. But do we get those dollars that we have not received in addition to moving forward? Do we get
I
those
see what you're
dollars as
saying.
well?
Okay. So the retroactive collection of payments, that's not, explicitly called out for in the compact, but this was something that the state took into consideration when we negotiated to get increases in revenue payments. The 2.5 billion guarantee over the first 5 years. I think if you look at some of the fiscal analysis, it seems evident that the tribe is probably not going to bring into the state 500 million a year if you just look at the revenue share percentages alone. But it was key to the state to get that minimum, understanding that we have not been paid in over a year. So yes, the negotiators, we did factor in additional revenue share payments to compensate the state for what it lost in the past. But you will not see that as a line item on the agreement. And given the legal nature, there are questions about whether or not such a line item would have been approved by Interior in the first place.
All right. Looks like Representative Woodson has another question.
Thank you. Actually, it's one last question that I have. This is our last class, and I want to make sure I'm clear because we're starting classes on Monday. So I apologize if I ask a lot of questions, but it's for my own understanding and clarification. The question that I have actually has to do with, now we know this is a no compact, things have been looked at and everything else. I still want some clarification as to who is responsible to oversee what got us in trouble, that kept us from getting this money that we were supposed to get, that we have not been able to get. Is it the commission or DBPR? Because in the contract, it's not really clear to me. Maybe it's something that I'm not seeing. So please just share some light for me, and that will be the last question that I ask.
So so the compact is not specific to DBPR or Gaming Commission because we weren't sure what you, the legislature, would want to do. So we tried to leave that open, and we talk about the state regulatory agency. If you do create a commission, then that body would have powers to conduct investigations, weigh in on disputes, conduct rulemaking, should you authorize it, etc. Right now, I think Ray previously mentioned, and I'll let him follow up if he'd like, that the state's regulatory agency and the Tribal Gaming Commission have worked well together in the past. Ultimately, this is somewhat like a contract between parties that, if there are disputes, you've got to take it in front of an arbiter, be it a court of law or the Gaming Commission, to make a decision. But if there's going to be a Gaming Commission, that's something you guys can decide. I believe that's contemplated, but I don't want to speak for you. And just to address your comment at the beginning about, the complexity and feeling like it's confusing, I will tell you, going back through Florida statutes, I still can't wrap my hand around some of the license moves that are allowed or not allowed, or who has a license here or tied it to here. It's not easy to understand, and it goes back, deep into history. So don't feel bad if you still have questions. We're all here to continue answering them.
I appreciate that. I appreciate that, and we give a lot of credit to Mr. Hammond actually for really doing a great job at clarifying some of the questions for us. And today as well, you and also Mr. Treadwell and Mr. Webster. So we appreciate it. And definitely that's something that we need to look at because every single penny counts, especially during those hard times. And we don't want to lose any money. So thank you so much. Thank you.
All right, does anyone else have a question? Representative Roth.
I don't get to ask too many questions, or I don't take the opportunity. So let me go ahead and ask the big elephant in the room question. What is the urgency of having the special session instead of waiting until next session and until January?
Sure. Well, I mean, the first thing is the state, every month that goes by, the state is losing out on significant revenues. I mean, we're up. I haven't looked at the updated total, but we're probably over 500 million now that we have not recouped for gaming that is ongoing. We also, you got to strike while the iron is hot. We've had some very productive discussions with the tribe. Again, the discussions over the last few years have kind of ebbed and flowed. There have been times where there seemed to be promise, and then times where people are slamming the table and walking away. We are at a point where both sides have made some meaningful concessions. The governor, under the law, is the chief negotiator. He came to an agreement that he felt good about, and following months of negotiation that the Senate president was involved in, and we certainly appreciate their hard work and guidance as we picked up the baton. So we feel like we've got a good deal now. I don't see the need to wait. I know that we just got done with legislative session, but from the questions, you guys seem bright and able to dig in quickly and figure it out. So there are a lot of moving pieces, as you've heard, with the designated player games and the sports betting and and Amendment 3 that dictate what we can do here. And we feel like for the first time, both parties see all those pieces and have found agreement. So we hope to get a deal done before we lose the momentum, if you will.
If I can make a comment, my comment would be, I agree with that. I think the hope was that there was some negotiations going on, that we could have done it during regular session, and we would have been able to do it over a month's time. But that was a lot to ask. So thank you again. Thank you, Kurt. Thank you everyone for this great casino U.
Thanks, Representative. I would have loved to do it during session 2, but Kurt kept sending us really complicated new pieces of legislation, and we just couldn't get it done in time.
All right. Does anyone else have a question? All right. I don't see any other questions, so I'll hand it over. Oh, looks like Representative Cheney does. I just sent me the request to unmute Representative Cheney. There you go.
Sorry, I clicked it. Does anybody know when the bills that are being proposed in addition to this are coming through? I heard that possibly today we may see as many as 7.
I guess I'll take that one. We are not 100% sure when they will be filed. The Senate may be first out of the gate, and I have heard rumors like you that maybe it is later today. However, we don't know for sure, and we will provide more information as it becomes available.
Okay, keeping my eye on my email.
All right.
Well, thanks everybody. I know you're in capable hands, but we're available if additional questions or need for clarity come in.
Yes, thank you to the team. I think we don't have any other questions, right, Lara?
Nope, we're good.
So thank you to the team from the Governor's Office and from the Seminole Tribe of Florida for joining us on this one and on the other trainings this week. At more than one point during several of the trainings, we've had over 70 participants, live participants, watching these training courses. So they've been wonderful. I want to thank Leader Grant and Chair Burton and Chairman Payne for being our moderators and kicking us off each day. And I want to emphasize to James, he said that we have a pretty bright group. I want to emphasize that they're more than bright now, James. They are graduates of the gaming edition of Legislator University. So I congratulate everyone. I wish we had little tassels for you, but Matt Ball, you know how he is. He wouldn't let us buy tassels. So I really appreciate it. And if you have any questions, get with any of the team members here in Commerce, and we'd be happy to help you. Thanks again to everyone.